Hey, this is Brenda with Berkshire Hathaway. How are you? Today I am with Rick. Hi, Rick.
Me, yeah.
Hey, how are you? At Equity Title, and something intrigued my interest when a lesson or a class or some information for us is about deed upon death, and I think that is so important that I scheduled Rick today to explain a little bit more about that. So, Rick, a little bit about deed upon death. What does that really mean, and why would a person do that?
Yeah, so deed upon death is an actual deed that is recorded with the county. They were very, very popular years ago, and it was a way of families to start the process of estate planning.
Okay.
So the theory behind it is we'll use a parents have children and they want to leave the house to their children. They don't have a trust. They don't have any other estate planning. Nevada law, it's actually the law is NRS 111.655, is talks about deed upon death.
Okay.
And what it allows is for people who are on title and own property to deed the property to anybody they'd like upon their death.
Okay.
Hence the words deed upon death.
Okay.
So like I said, it's a recordable document. It is a deed, just like a grant bargain and sale deed
Okay.
or a quitclaim deed. It just has some other features to it. It outlines who the current owners are,
Okay.
who they're deeding to upon their death, and the rest of is the recording at the county. So every county in Nevada has their own recording office. So,
Okay.
and ours here in Clark County would be the Clark County Recorder. They would have the document notarized, signed off on by the owners of the property,
Okay.
and then recorded at the county. It would be on the chain of title, meaning that it would be of record. And when they pass away, the last surviving person passes away, the deed is not officially transferred automatically. There's other documentation that has to be done,
Okay.
but they would be the legal owners of the property at that time. In the past, it was to avoid probate. It was to avoid any type of estate transfer that may have to go through the courts.
Okay.
Now the laws changed a little bit, and in 2021 they came out with some other provisions to it. So it's not as easy as what it used to be, but it's still a great planning tool if there's not a trust or other estate planning solutions in place.
So I kind of want to backtrack a little bit. So when you have a deed upon death, you really need to have it recorded before the party's deceased, right?
Correct. A lot of times people will actually execute this document and they will just throw it in the drawer. And don't do that. You need to have it recorded. It needs to be recorded at the county that you live in or where the property is.
Okay.
And that'll put it of record so that when the last surviving person does pass away, it is in the process to help with the transfer of the title.
Okay. And that was before the rules have changed. That was before. Now,
Yeah.
we're talking about state of Nevada now. So you might want to go ahead and talk to your closing agents in what state you're in to make sure that your home won't need to go into additional situations. But right now we're talking about Nevada. But it's a good idea to maybe do your due diligence, and make sure you double check with the state for which you live in. Okay.
Definitely.
So then the things have changed, and so now we're talking about changes, right? So
right, and there's two pieces to this. You have to kind of break them apart. The first piece is here's Nevada law, and here's what happens. Deed upon death is a good tool to have in place, and like everything we discussed, the last surviving person passes away and then is on record.
Okay.
There's the second piece to it, which comes from the title company side. When you're going to sell the property, there's certain steps that changed that need to happen. One of them, in the past, there was no probate that was needed. Now there is a probate that is needed. However, the probate that's needed doesn't include the property. It's there as a catch-all for any of the debts that could attach to the property from the previous owners, from the people that have passed away.
Okay. So then what's the next step?
So the next step, if you have a deed upon death on your property, and say it's your parents and they're completely passed away, there's another document that you would have to execute in front of a notary and then record into your name.
Okay.
So that will transfer it into the names, or the names, multiple names that are on that deed upon death.
Okay.
The next step after that would be to actually get with a probate attorney, or do what's called the Independent Administrators Act probate, and open a probate. Now that probate is not going to include the property. It's going to include everything else, and it needs to be open. And the reason for that is when we're insuring the property from a title company's perspective, we need to make sure certain things are taken care of. One, is there any Medicaid balances that are due?
Oh, okay.
So that we have to get a letter from Medicaid that there's no money due to them. Two, are there any creditors that could potentially attach to the property? So they have to be notified. There's notifications that are sent out. We have the heirs of the property need to send out 3 notices through legal news, so that the creditors could be put on notice.
Okay, so that's kind of like a 90-day.
It isn't. It's exactly what it is. It's a 90-day process. They need to be published. So Nevada Legal News would be the publication. 3 separate times within a 90-day period, and they have to be, I believe it's 2 weeks apart from each other as well.
Okay, so we talked about probate, we talked about Medicaid, we talked about the letters. Remember, they have to be 2 weeks apart. Is that right?
Right, and normally in that situation, you will hire an attorney. The probate attorney will handle those for you.
Okay, perfect.
It's easier to do it that way. There's letters of service, meaning the publication that you use will actually provide you with letters saying that you have posted in those on those dates, and we'll need that as well. Okay,
and then is there something else that they need to make sure they do?
So those are the big ones right there. I mean, everything else that could come up would be just a normal title issue that could occur on any property. But the biggest thing in that is making sure the deed upon death is then transferred to the actual heirs. So there'll be a deed for that. Opening the probate, serving the notices and publicizing them, and looking into the Medicaid situation to make sure that there is no balances due with Medicaid.
Okay, great.
Once that is taken care of, we have the 90-day waiting period, and then title companies are able to insure at that time.
Okay.
Well, some of them are, some of them are not.
Okay, so when you say insure, let's go backtrack, because a lot of people don't understand the insure part of a title thing, and so this is really important. When we talk about insured, is that title insurance?
It is title insurance. So on every transfer of a property that we're involved with, we offer, and in all the real estate agreements, they talk about an owner's title policy. So we offer an owner's title policy from the seller to the buyer that basically states that when the buyer takes over, they're going to have free and clear title of everything in the past.
Okay. So when so for example, if I'm just going to throw it out there, that example, if I buy a house and it's on property that's maybe a couple 100 years old or 100 years old or whatever. So that covers previous years of ownership that they can't claim your house because it has title insurance.
Correct. You'd have insurance. If somebody made a claim, you'd have insurance up to your purchase price in most situations that you'd be covered in that.
Okay, perfect. And so I always recommend you looking into that and discussing with your closing agents on how that kind of works in your state. So when you're in the process of your estate planning, right? So it may be a good idea to look into what state you are in to find out if this is the best solution for you, whether it goes into probate, whether it doesn't. But another solution that a lot of people do is a trust. So we highly recommend you talking to a trust attorney. Is that right?
Correct, yes.
To get your finances in order and get your things in. But with a trust, that kind of means that the people don't have to go through probate. Is that right?
Correct, yes. And 99.9% of the time, there are certain instances where something might have been done wrong. And they would have to. But for the most case, and the purpose of this, they do not have to go through a trust, or a probate, if the property is in a trust.
Right.
Because the trust is a separate, basically, entity from the original owners. And it has its rules and regulations of how they want this property to be transferred, and who can control the trust. So all of that is set forth, where on a regular property that's owned by individuals, once they pass away, there's nothing set that says what's supposed to happen other than a will, and people can contest wills. Where a trust, it's set out, and they normally cannot be contested. And the people who have the authority to act on behalf of the trust can sell a property. They could keep the property, whatever is written in that trust, that's what they're going to follow.
And they have to follow that by law, right? Or
Correct,
by that trust. And so the trust attorney will give you all that advice and tell you, the ins and outs of a trust. But again, if you don't want to go through probate or want your families to go through all that things, it may be a good idea for you to look into talking to a trust attorney to get all your finances in order. So Rick, I want to say thank you so very much for spending time with me today. I hope you enjoyed this. I hope you got some information on that. Please make sure you talk to your closing agents within your state. And remember, we're talking about the state of Nevada here. So again, thank you so much for your
You're welcome.
time, and I
Thank you for
greatly
having me.
appreciate it. This was fantastic. Thank you, and have a fantastic day.